Bernsketter, Carter, Coleman, McCreary, Weber.
All right, we will begin with a public hearing on House Bill number 68. Representative, please come forward, and you may proceed when ready.
Good morning, and thank you, Mr. Chairman and other senators of the committee. My name is Matthew Overcast. I am the representative for 155. That's Douglas, Ozark, Taney, and Stone counties. So I'm here today to talk to you about House Bill 68. House Bill 68 addresses the statute of limitations in two civil contexts, one with regard to personal injury, and also on the other side, an amendment that was added on the floor with regard to childhood sexual abuse claims. So to the first point, House Bill 68 reduces the statute of limitations currently from 5 years to 2 years. A lot of our neighboring states have already done this. In fact, over 45 states are currently operating with the lower statute of limitations when it comes to personal injury claims. Opposition to this bill often says it impacts a person's ability to bring a claim in their day in court. That's simply just not true. If it was, you'd see states like, so for example, Minnesota just went from 6, I think it was the last couple of years, went from 6 to 2. And what do we know about the state of Minnesota? Well, they're one of the more progressive states in the nation. And I say that, don't latch on to that progressive word, but the fact is, their claim to fame is that we're access to justice. We're access to our day in court. If that was truly the case and it impeded a person's ability to bring a legitimate claim, you would see them reversing course and going back to a higher statute of limitations. Missouri is in the top category as far as that goes. There's only 2 or 3 states with a higher statute of limitations. This has real impacts for the business community and also for the individuals who are bringing these suits. It's a matter of judicial fairness. As time goes on, memories fade, evidence does not get better. The only person that wins with the longer statute of limitations is the attorneys who are arguing those cases. It certainly doesn't help the victim. I know that I've deposed people who I legitimately knew had probably decent claims, but people when memories fade, people stumble over those things, and it does create issues for their case. Likewise, it's very hard to defend a case if you're a Missouri small business. Let's just say, for example, you are a retailer, right? What do we know about retail? Retail usually has high turnover. If an individual waits to bring a claim for 3, 4, 5 years, then I, as the small business owner, I didn't have the opportunity and notice to preserve evidence, to get the statements from employees and things to build my defense. And that puts me as a small business owner in very bad shape. Which brings me to I'm going to pivot over to the amendment that Representative Seitz offered on the House floor, which was to extend, on the other hand, the statute of limitations and childhood sex abuse cases. Currently, as it stands, they must be commenced within 10 years of a plaintiff turning 21 or within 3 years of the date the plaintiff discovers or originally should have discovered the injury or illness that caused the sexual abuse. This bill would change that from 10 years to 20 years for any actions that occur after August 28th, 2025. This bill isn't about denying justice. It's about judicial fairness for all parties, and with the lovely addition from Representative Seitz, also about allowing victims of childhood sexual assault their day in court. This bill is fantastic in my opinion, but I would love to hear what the committee has, and with that I'll open it up for questions.
Questions for the bill sponsor from the committee? Yes, Senator, please proceed.
So Minnesota's got a top tax rate of 10%. Would you like to see that in Missouri?
Absolutely not.
Okay, thank you.
Further questions for the bill sponsor? Seeing none. How many witnesses are here to testify either for or against on this bill? Okay. We're going to attempt to go with just regular witness testimony. We do have an abbreviated amount of time here, so I would ask the witnesses to keep their comments as succinct as possible. We do want to hear everyone's testimony, but if we start to run low on time, we may have to impose some kind of time limitation on witness testimony. So with that, first witness in support, please come forward and proceed with your testimony. And if witnesses would make sure they filled out witness cards, that would be helpful as well.
Good morning. My name is Dana Fries. I'm President and CEO of Healthcare Services Group in Jefferson City, Missouri. We are a member-owned insurance organization. We're owned by Missouri not-for-profit hospitals located throughout the state of Missouri, both large and small. A majority of our member hospitals are small rural hospitals. We provide liability insurance for member hospitals, over 2,000 physicians and thousands of nurses and other healthcare providers. We provide both medical professional liability insurance and general liability insurance, so we specifically deal with general liability claims and have for many years. I'm testifying today on behalf of the Missouri Organization of Defense Lawyers and the Missouri Hospital Association. Statute of limitations aim or purpose is to ensure that evidence is fresh and reliable for both parties, the plaintiff and the defendant. The defendants should not have the threat of litigation hanging over their heads indefinitely. It is very important to remember that it is not unusual for the first notice of a claim to be the filing of a lawsuit. And if that lawsuit is filed 4 or 5 years later after the event in question, such as a slip and fall event at a retail establishment, and those employees are long gone, the defendant is at a disadvantage. Missouri's 5-year statute of limitations, as noted by Representative Overcast, is one of the broadest in the United States, and that has been the case for many years. Permitting an individual to file a bodily injury lawsuit 5 years after an accident is fundamentally unfair to the defendants who reside or do business in the state of Missouri as compared to other states. During the span of 5 years, I think we can all relate to the fact that evidence can be inadvertently destroyed or misplaced. Witness memories certainly can and do fade. In other words, evidence becomes stale over time. In terms of attracting business to the state of Missouri and maintaining business in this state, Missouri's 5-year statute of limitations puts our state at a competitive disadvantage. Our neighboring states have the following statute of limitations for general bodily injury claims: Arkansas, 3 years; Illinois, 2 years; Iowa, 2 years; Kansas, 2 years; Kentucky, 2 years; Nebraska, 4 years; Oklahoma, 2 years; Tennessee, 1 year. 25 states currently have a statute of limitations of 2 years, the time frame proposed in House Bill 68. Missouri's 5-year statute of limitations dates back to 1939. It has not been amended since then. I think we can all agree that access to legal representation, if you're a claimant, is much more accessible in 2025 than it was in 1939, especially with the internet, social media, and lawyer awareness through extensive advertising. If you need a lawyer, you can find a lawyer in this state. Requiring lawsuits to be filed within 2 years is better, on balance, than being subject to suit later in time when legitimate defenses are more likely to erode. As noted previously, sometimes our insureds are unaware of a claim or even an accident having happened until a lawsuit is filed. And then they have to respond to the lawsuit. and are at a disadvantage in that circumstance. Now, as the president of an insurance organization, I don't like paying defense lawyers. We like to resolve cases if we can. Adopting a 2-year statute of limitations should not result in a flood of lawsuits or a rush to the courthouse over time. You know, we routinely enter into tolling agreements with plaintiff lawyers if we're making progress towards trying to resolve a case and we need a little more time. We can agree in writing to extend the statute of limitations for a period of time while we continue to negotiate. That's beneficial for the plaintiff. It's also beneficial for the defense, because if I can avoid having to hire a defense lawyer to defend an unnecessary lawsuit for a case that ought to be settled, it's in our interest to do exactly that, which is to extend the statute of limitations on a case-by-case basis, and we do that frequently. We also frequently resolve cases without a lawsuit being filed. In fact, one of our claim representatives reached out to a lawyer last week and said, you know, I understand you're ready to file a lawsuit. You don't have to do that. Send us the medical records, the medical bills. We'll try to resolve the case with you so you don't have to file a lawsuit and we don't have to hire a lawyer to defend the case. It's good business for us to want to do that. We do business in Illinois and Kansas, so we're not seeing injustice in those states with the 2-year statute of limitations that they have in those states. So I don't think it's going to create unfairness in the state of Missouri compared to the litigation environment in other states. So in our view, House Bill 68 strikes a reasonable and fair balance from a public policy standpoint by imposing a 2-year statute of limitations that is similar to the majority of the states in this country and certainly the sister states around the great state of Missouri. You will hear from the plaintiff's bar routinely the right to a jury trial under the 7th Amendment. Well, defendants are entitled to a timely jury trial under the 7th Amendment as well. They're entitled to know when a claim is presented timely so they can prepare a defense, because the plaintiff has the burden of proof, not the defense. So I respectfully request that this court vote in favor of House Bill 68. Thank you.
Thank you for that testimony. We appreciate the promotion to court. Any questions for this witness from the committee? Seeing none. Thank you for the very excellent testimony. Next witness in support. Next witness in favor, please come forward and may proceed when ready.
Chair Trent, members of the committee, my name is Luke Reed, and I'm with the Missouri Chamber of Commerce and Industry, here to voice our support for House Bill 68, as it extends the statute of limitations for personal injury. We think this is great for economic competition, and it does not at all infringe upon a person's 7th Amendment right. It's a big step in making Missouri more competitive economically. If we look to our neighboring states and the states we compete with the most, so Georgia, Indiana, Kentucky, Tennessee, they're 1 or 2 years. So we feel like this 2-year limit is very reasonable in the big scheme of things, especially considering Missouri is an outlier right now with 5 years. So, and also I wanted to address the other part that was added as an amendment by Representative Brian Seitz, the child sexual abuse, moving it from 10 years to 20 years. We think this is a reasonable measured change, and it's important to secure justice for those who have been wronged. So we support House Bill 68.
Questions for this witness from the committee? Seeing none. Thank you for that testimony. Next witness in support.
Mr. Chairman, members of the committee, Jorgen Schleymeyer, I don't have really much to add on behalf of the American Tort Reform Association in support of the bill.
Thank you for that testimony. Questions for this witness? Seeing none. Next witness in support.
Morning, Mr. Chairman, members of the committee. Mark Figgenbaum with Missouri Farm Bureau. We have member-adopted policy supporting this bill, and so we are in support.
Thank you for that testimony. Questions for this witness? Seeing none. Thank you again for being here. Next witness in support.
Good morning, Chair Trent, members of the committee. Philip Arnzen with the National Association of Mutual Insurance Companies. I don't have anything else to add. We're in support of the legislation.
Thank you for that testimony. Questions for this witness? Seeing none. Next witness in support.
Good morning. Matthew Smith with Associated Industries in Missouri. Just want to go on record of support of this bill.
Questions for this witness? Seeing none. Thank you for being here today. Next witness in support.
Mr. Chairman, Brad Jones with the NFIB, and I think we've testified on this, I'm not sure how many times, but I'll just add one more today. How's that? So,
Well, we appreciate that. Any
All
questions for this witness?
Thank
Seeing none. Next witness in support.
Mr. Chairman, members of the committee, David Overfelt from the Missouri Retailers Association and the Missouri Grocers Association in support of House Bill 68.
Thank you. Questions for this witness? Seeing none. Next witness in support.
Good morning. My name is Dustin Sherbeck, and I'm speaking on behalf of Missouri Canoers and Floaters Association, and I'm in support of this bill.
Thank you for that testimony. Any questions for this witness? Seeing none. Thank you for being here. Further witnesses in support.
Yeah. Mr. Chair, members of the committee, Kaina Iman on behalf of the Missouri Association of RV Parks and Campgrounds. We're in support.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support.
Mr. Chairman, the parade continues. My name is Doug Galloway. I'm here representing Ford Motor Company in support of House Bill 68.
Thank you for that testimony. Questions for this witness? Seeing none. Next witness in support.
Larry Case, today representing the Missouri Association of Insurance Agents, speaking on behalf of them in support.
Thank you for being here. Questions for this witness? Seeing none. Next witness in support.
Morning, Mr. Chairman. Hampton Williams, General Counsel for the Missouri Insurance Coalition, testifying in support of this legislation. Happy to answer any questions if there are any.
Questions for this witness? Seeing none. Thank you for being here. Further witnesses to testify in support.
Good morning, Mr. Chair, members of the committee. My name is Jackie Barget, registered lobbyist here on behalf of State Farm Insurance Companies, and we'd also like to go on record in support.
Questions for this witness from the committee? Seeing none. Thank you for being here. Further witnesses in support? Seeing none. Any witnesses here testifying in opposition? Please come forward. May proceed when ready.
Hi, Senators. Thank you so much for allowing me to speak today. My name is Stephanie Black. I just want to give some background information on myself. I've been an attorney for the last 13 years. The first 6 years of my practice, I practiced exclusively in Illinois. I did start out as a prosecutor, then I moved to become a civil defense attorney where I represented Fortune 100 companies, school districts, and other corporate entities. I then moved to a plaintiff's firm where I represented injured people in Illinois, but I also represented cities and municipalities. For the last 7 years, I've been in St. Louis, which is obviously right across the river from Illinois. So I do my focus is on plaintiff's work, but I have cases in both Missouri and Illinois. So I think I'm coming to you today with a relatively fair and balanced background of having experienced both sides, the defense attorney cap and the plaintiff's attorney cap. So I kind of want to just start with just some background information of why the statute of limitation is so important and why as attorneys we are so particular in making sure that cases get filed within that time frame. Every attorney who practices litigation in the country probably has had the experience of waking up in a cold sweat in the middle of the night thinking, oh my gosh, did I file that case in time? It happened to me, unfortunately, one time when I was in New Orleans on a vacation with my husband, so that was quite a buzzkill. So it's one of those things where we all, and the reason is because this is such a fundamental right. You cannot, when you're representing somebody, whether it is a small business, whether it's a city, municipality, or an individual who's been injured, you have to protect that claim, whatever it is. So it's not like we as attorneys are just ready, we're lawsuit happy, trying to get a case on file. A lot of times when these cases are filed, it's because it has to in order to protect that statute of limitations. And it's not like you just file the lawsuit with the courthouse or on the CaseNet system or whatever you have, and you hit the ground running and you go after them. You have to get defendants or defendant or defendants served. And that is easier than it sounds sometimes. I mean, I just recently had a case in Illinois where the registered, I don't know how this happens, it's Illinois, the registered agent was registered at a building that did not exist. So the sheriff's deputy goes out there, tries to serve somebody, and it comes back, building doesn't exist. So then we have to go through this whole process. It took 4 months to get this person served. So the best practice for any attorney with a statute of limitations is when you're coming up on what you believe to be that statute of limitations is you start thinking 6 months ahead of time. Hey, we got to start thinking about getting this lawsuit on file so you have time to get the defendant served so you don't run into any issues with your client's case potentially being thrown out. So, and then when you're talking about Illinois that does have that 2-year statute of limitations, one of the other big pieces of a problem with this is, well, I don't want to say a problem, but it's just the fact of life. And in America, as our healthcare system, it takes a long time for people to really get into specialists, to see a doctor. I mean, if you try to change your own doctor's appointment, it's like, we'll see you in 2026, you know? So especially when you're trying to get in to see specialists like neurosurgeons, orthopedic surgeons who are trying to see, hey, do you have some sort of back injury? And then every surgeon in America will tell you, hey, if we can try to do conservative treatment as opposed to surgery, that's what we want to do. So maybe your client has injections every 6 months and you're waiting to see. And so then maybe your client takes about a month, or I'm sorry, about a year until the doctor says, okay, you're at your baseline now. Well, now it's going to take about 60 to 90 days to get the medical records and bills. So you're already at a year and change in Illinois, and you just finally got the full picture of what are the harms and losses, what are the damages to this individual or you know, or whoever you're representing. So whenever, and then you're coming up on that statute, it's kind of one of those things where, in my experience, it's really not a lot of times, you don't have the time to negotiate with claims agents or to try to get the case settled before. And so what this leads to is having to file the case to protect that statute of limitations. And I'm not blaming insurance adjusters in Illinois for this, but they know the statute too. So in my experience, as an attorney practicing personal injury in Illinois, you just don't get generally reasonable offers and negotiation before you file suit, especially if you're coming up, if you're a year and 3 months, coming close to that statute. So you've got this faster filing. And then what the other thing is, it also leads to having to name more defendants, because you don't always know exactly who's going to be the entity responsible. So it's really just, you can't risk not naming someone. The other thing I would say, which happens to me all the time in Illinois court, is when you're forced to file before your client's done treating, you kind of get stuck in what's called case management conference limbo, or what I call it as that, because you can't really do substantive discovery while somebody is still treating, because neither side knows, hey, what's the full picture here? What are we talking about? So basically what that means is every 60 to 90 days, you have to go back to court, tell the judge, plaintiff's still treating, we can't really do depositions, we don't know what's going on here. This literally happened to me, and I represent a lot of injured railroad workers who obviously they're covered under the Federal Employers Liability Act, and that's a 3-year statute of limitations. Most of them have pretty significant injuries. We're talking about railroad workers. even in those cases with a 3-year statute of limitations compared to the 2 years that Illinois is and what's proposed here, 95% of those cases have to get filed because the client's still treating. I had a case in Cook County where the trial kept having to get continued because the client had to get surgery and it kept getting delayed. His treatment kept getting delayed. So through no fault of his own, the railroad was having to pay their attorneys by the hour, and we're stuck in this limbo of, why are we doing this when potentially if we had that time, we could have, maybe gotten that case settled before. So, and I'll just comment to the fact that, having been in Illinois courts and in Missouri courts a lot, and I've tried a lot of civil cases in Illinois, so I'm coming to you with experience of doing that. I can tell you, a progressive state or a so-called progressive state does not necessarily mean judicial economy and efficiency. So I don't know that that's really what we want to model our court system off of. And so the way Missouri does it is it really does allow for those pre-litigation discussions and good faith negotiations, and really regularly, very regularly, I'm able to settle cases that wouldn't necessarily need to be filed, but if it were in Illinois, it would have had to have been filed based on that 2-year statute of limitations. So with that, I'm happy to answer any questions.
Thank you for that testimony. Questions for this witness from the committee? Seeing none, thank you again.
Thank you.
Further witnesses to testify in opposition, please come forward. You may proceed when ready.
Good morning. So my name is Wes Shoemate. I'm an attorney from Kansas City with the law firm of Davis, Bethune & Jones. I'm also here with the Missouri Association of Trial Attorneys. Ms. Black did a good job of talking generally about the issues with a more restrictive statute of limitations. I want to try to address some things specifically and answer any questions you have about that. In our practice at my firm over the years, we have handled and continue to handle many cases involving sexual assaults and sexual abuses, not only with children, but with adults, with women, in both the workplace and other professional settings, such as massage parlors, such as chiropractic offices. Here's the deal. In our country, every 68 seconds, somebody is a victim of sexual abuse. Every 68 seconds. Only about a third of those get reported timely. And I'm talking about just to a loved one or just to somebody close. There are many reasons for this. A lot of it is that a sexual abuse is one of the hardest, most damning types of abuse someone can suffer. It affects you emotionally, it affects your relationships, your personal relationships, your relationship with yourself, your sense of comfort, safety in society and at home. Everywhere you go, you carry that. A lot of times it's hard for a victim to come forward and talk about that. Most victims will have at least some, if not all, signs and symptoms of post-traumatic stress disorder. One of the key indicators of that is avoidance. Avoidance of what happened. Avoidance of reporting, avoidance of talking about it, wanting to get away. Some feel threatened by their attacker, threatened by their abuser. Some just can't deal with it and need time. A shortened statute of limitation, I can tell you from a specific case. I can't reveal identities because I wouldn't do that to someone I represented in a case like that. But recently, I had a string of cases against a local massage parlor in the Kansas City area. 2 of my clients were abused by the same man in the same fashion on the same day in December of 2022. These 2 women had different backgrounds, different histories, different makeups. One went straight into fight mode, went straight home, went to the police department, reported. The other had been abused as a child. Things were triggered for her. She immediately left town and moved to her parents' home in Kansas and lived there for the next 2 years. We were able to quickly get involved with client 1's case and help her get to a resolution. She only learned about client number 2, who was there the same day when the 2 of them ran into each other 2 years and 4 days after this happened, just after Christmas this past year. If my client number 2 had found the strength and support to come forward in a state like Kansas, like Illinois, like Tennessee or Kentucky, she would have been forever barred from bringing that claim for the abuser And by the way, at this place of abuse, the owner and facilitator of that massage parlor was the wife of the attacker who was allowing this to happen. Happened to up to 9 women in Kansas City over a 2-year period. They would have been barred. For that reason, I think we should look a lot closer at this and realize that it is not bringing anything to help the citizens of Missouri to shorten this to 2 years. This doesn't just go for the example I'm giving you. In cases involving traumatic brain injury, involving traumatic spinal injury, cases involve multiple surgeries, as Ms. Black talked about, it takes time to develop. It takes time to figure out just what harm there is. I know it was mentioned by one of the in favor that this statute's been here since 1939, and they went on to talk about evidence, but I would tell you this. We do a lot better job of preserving evidence and finding evidence in 2025 than we did in 1939. It's not like things are being lost that quickly. I'll also tell you with respect to the section in the amendment about uninsured and underinsured motorist coverage, I noticed most of the in favors were here representing insurance corporations or insurance groups. That's because that section only protects insurance companies. That has nothing to do with Missouri citizen protection. A UIM claim or a UM claim is made directly against your insurer, your own insurer that you paid your premium for. Currently, the statute of limitations is governed by contract law. Like every other contract any business or private person in Missouri has, written contract statute is 10 years. There's no reason to give an insurance company out of having 2 years for that. It makes no sense. With that, I'd pass for any questions.
I have a question.
Proceed.
Just for clarification, we're working on House Bill 68, is that correct?
Yeah.
And my understanding is that there is, on page 2, lines 10 through 14, a 20-year statute of limitations. So it seems to me that your testimony is very, very specific and not particularly, on point. I think what you're trying to imply is that if we were to loosen the statute of limitations, that we would all be fine with hurting sex-offended victims. Frankly, I find that caricature offensive. I think it's not true. And I was looking at the statutes in other states, and I don't believe that you mean to say that about the legislature and those who are elected in West Virginia, Washington, Virginia, Vermont, Utah, Texas, Tennessee, South Dakota, South Carolina, Rhode Island, Pennsylvania, Oregon, Oklahoma, Ohio, North Carolina, New York, New Jersey, New Hampshire, Nevada, Montana, Nebraska, Mississippi. The list of states goes on and on that have lower statute of limitations than Missouri, and I find your characterization and your testimony offensive. I actually don't really have a question. Thank you, Mr. Chairman. No, sir, I'm good. Thank you.
Okay.
Any questions for the witness from the committee? No. Seeing none.
Okay.
Thank you for that testimony.
Appreciate it.
Further witnesses in opposition? Yes, please leave a witness card at the front desk if you have not already. Please proceed when ready.
Thank you, Chair. Thank you, Committee. My name is Bobby Thrasher. I'm a plaintiff's attorney in Kansas City as well at a firm called Monsees and Mayer. I will try to keep this short, not to duplicate other testimony. I too represent victims of sexual abuse, but also personal injury. I believe, there are a lot of people here testifying in favor. They're on behalf of companies or community organizations or corporations. I'm here on behalf of my clients. In a large part, I'm here on behalf of the individuals of the state of Missouri and your constituents. A personal injury matter is very personal, and I don't know if any of you have been in a car accident for simplistic sake, but it does upend your life. It does cause a lot of frustration and delay, and minimizing or shortening the statute of limitations is not there to help the person. You are going through your own tragedy. You're trying to figure out your new normal, and all it is doing is adding stress and frustration to an already stressful and frustrating situation. So it is a personal one. It's not a one to be reserved for businesses or corporations, and I hope you guys can see that difference. The other thing I want to point out is the contradictory nature of this bill as written, along with the sexual abuse provision added by Representative Seitz. What this bill is ultimately saying, as it's being presented and read, is if you are raped at 17, you do get the benefit of an extension of a statute of limitations for your case. If you're raped at 18, you have 2 years. There should not be that stark difference based on whether you are raped as a minor or whether you are assaulted or raped as an adult. That contradicts, and that is very hypocritical, I guess, for a lack of better terms. I sat in this very lounge for 2 hours this morning under another sexual abuse bill where we had dozens of victims testifying on behalf of it. You do not see those victims here. I hope that is telling. There are other vehicles, there are other bills that are being pushed through these chambers and the House that protect victims of child sexual abuse, and this is not their preferred vehicle. So I can take any questions if there are any, but I don't want to waste any more time.
Questions for this witness from the committee? Seeing none, thank you again for being here. Further witnesses in opposition? Seeing none, are any witnesses here to testify for informational purposes only? Seeing one, perhaps? No. Seeing none, that will conclude the public hearing on House Bill 68. And we will next go to public hearing for House Bill numbers 567, 546, 758, and 958. Representative, please proceed when ready.
Good morning, or well, almost, it's still good morning. Good morning, Mr. Chair and Committee. My name is Representative Sherry Gallick. I represent District 62, which is Cass and Bates County, on the western side of the state. I am here to present my House Bill 567. Proposition A implemented a minimum wage increase and paid sick leave mandate, creating a 1-2 punch for Missouri businesses. In my bill, the minimum wage increases are left intact. January 1st, minimum wage increased to $13.75, with workers getting an 11.7% pay raise. On January 1st next year, 2026, the $15 minimum wage will be implemented for an overall pay increase of 21.9%. But the flip side of that is that very few, if any, businesses will see an increase in profits at 21.9% in 1 year, and businesses continue to see rising costs in supply chain goods. Competition is one of the biggest things to consider when you're starting a business or conducting business. The minimum wage and benefit mandates are far less in bordering states that surround us, and it makes it easy to cross the state border and relocate. For instance, many of the bordering states are at 725. Arkansas is at 11, Illinois is at 15, and actually, if you're under 18 in Illinois, it's 13. In front of you, there should be a chart of the cost of living and the minimum wage ranking. Missouri ranks 18th in minimum wage nationwide now, and 46th in the cost of living. This is a significant discrepancy, and why my bill discontinues the annual cost of living minimum wage. In 2026, we will have the 8th highest minimum wage in the country. In January, private industry has already seen job loss numbers of 18,800 private sector jobs that minimum wage likely contributed. But it is the sick leave that disproportionately harms businesses, causing potential disruption to project timelines and temporary business closures, all of which increase the cost of goods and services. Real-world scenarios highlight why a one-size-fits-all sick leave mandate is impractical and costly. In Missouri, there are many businesses that already offer a sick leave in the benefit package, which is why I believe that this issue should be decided between an employer and an employee. With additional mandates, business may be encouraged to evaluate the total cost of an employee versus investing in automation. We already see this in self-service kiosks and checkouts, in grocery, mass merchandisers like Target and Walmart, and even in restaurants. But it is rural America where small businesses will suffer the most, both the employees and the businesses. I have businesses in my district and surrounding districts that mention moving across the state line to Kansas, cutting hours, reducing staff, and some even closing their doors. And if you will indulge me for just a minute, I have put several emails or letters. I didn't, but anyway, they should be there for you to look at. But one says, Prop A, once fully implemented, will cost my company an additional $400,000 per year in wages and PTO. There are many past years in which the $400,000 would account for more than 75% of the net profit that our company earns. That is driving a stake in the heart of the independent grocery stores in small town Missouri. I had an opportunity and the intention to purchase a competitor's grocery store in 2024, but after learning that Prop A would be on the ballot, the math changed and the store was no longer profitable enough to take the risk and endure the hassle. There's also a business that says our company always makes production schedules a week ahead of time, and we try to limit our Monday morning surprises. We have a startup employee that comes in Monday morning around 1 a.m. to start and schedule machines. The machines take approximately 4 hours to warm up. It is heart-wrenching when you get a call and find out when an employee won't be in. And lastly, the recent passage of Proposition A in Missouri, which mandates increases in the minimum wage and requires employers to provide sick leave, has further increased our overhead expenses. While we firmly believe that our hardworking staff deserves fair compensation and benefits, the financial realities of current economic environment make it challenging for us to provide this without imposing higher prices. After careful consideration, we have concluded that closing our doors is the most responsible course of action. So those are just a few of the businesses that I have heard from. Sick leave mandate is complex, and running or owning a business is not a one-size-fits-all, and all businesses don't operate alike. Beyond the financial burden, the sick leave mandate brings new accounting practices and legal risks for employers. Under the mandated sick leave provisions, an employer cannot ask why an employee was absent, leaving the employer vulnerable to lawsuits for merely attempting to manage and plan their daily business. Employers can be charged with large fines and even jail time. And for brevity and Senate practices, I am trying to keep this short, so I'm happy to answer any questions.
Questions for the bill sponsor? Yes, Senator, please proceed.
Representative, I want to thank you for your presentation and tell you that the traditions of the Senate are not brevity. So if you had anything else, I'm happy to hear it, but thank you for your introduction.
Further questions for the bill sponsor? Yes, Senator, please proceed.
Thank you, Representative. I assume you support our Governor Mike Kehoe, and I assume you support our country's president, President Trump. Are you confident that the Trump-Kehoe economy is going to be good for Missouri businesses for the next few years?
That's kind of above my pay grade. I have my own personal
Well, I'm asking for your
things.
personal opinion, yeah.
Well, I don't think that's relevant to this bill. I mean, I'm here.
I'm just asking if you think
Yeah,
President
no,
Trump is going to do a good job running the economy the next 4 years.
I understand, but I am concerned about Missouri's economy. That's why I'm here, because I'm fearful that this could impact Missouri businesses.
Right. So are you confident that the business environment for Missouri's businesses over the next few years, 'cause you're talking about rising supply costs, and that was one of your justifications. So are you concerned that President Trump's not going to bring down supply costs, and that supply costs for business under President Trump and Governor Keogh are going to go up a lot over the next few years?
I don't have, ESP, so I don't know what's going to happen. I am concerned with Missouri. Do I think that prices are going to increase?
Okay, so
inflation has already happened, and so I don't think they're going to go down. I bought eggs the other day, and I about fell over. I went to Sam's, and it cost almost $10 for
in the Trump economy.
Eggs. So, President Trump doesn't talk to me. I don't have a direct line to him. That's about.
I know. I'm just asking you as a representative for your
Yeah.
personal opinion. I assume you support him. Do you think that President Trump's going to do a good job running the economy? Are businesses going to make big, beautiful profits over the next few years, or are you concerned that maybe Trump's policies are going to inflict costs on small businesses, and maybe that's the issue we need to be concerned with the next few years?
Again, it could be. I don't know. I'm hopeful that it doesn't, but
I'm just asking your
yeah,
opinion.
no, I understand.
You don't have an opinion on that,
I hope that it doesn't.
right?
When you look at economics, and honestly, just from being in this building, it's hard to even keep up with federal stuff because I'm too involved with state
Well, okay,
stuff.
then we'll go with Governor Keogh. Are you confident
Yeah.
Governor Keogh is going to bring down prices and help Missouri consumers and businesses over the next few years?
Governor Keogh doesn't really set prices on a lot of things. Private business usually sets pricing. I did that in my career. I did set pricing, and it's a balancing act. You have to look at what a consumer or a business, if you're doing business to business, is willing to pay versus your profits.
Okay, so
raw
it
material costs.
wasn't Biden, all those
Yeah.
the Biden inflation stuff I saw. That was all wrong. It wasn't Joe Biden's fault that there was inflation.
You know what? I don't really comment on what federal government does.
Well, that's Representative. I want to try to work with you on this bill, but you don't have a lot of opinions. It's hard to understand where they start and where they end. But thank you. I appreciate it. I'll save the rest for the floor. Thank you.
Well, I appreciate the anticipation of this going to the floor.
I think we've had a lot of dead bills in committee today, Mr. Chairman.
Thank you, Senator. Further questions for the bill sponsor? Seeing none, could I get a show of hands of how many witnesses are here to testify on this measure? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Looks like roughly 10 folks. So that seems very doable with the time that we have remaining. So we'll begin with witnesses in support. Please come forward. Make sure everyone's filled out a witness card and proceed when ready.
Thank you, committee, and Mr. Chair. My name is Buddy Law. I'm the CEO of the Missouri Restaurant Association. The restaurant industry is an industry of opportunity, and the sick pay requirements outlined in Proposition A are simply not good for the restaurant community or small businesses in Missouri. Proposition A has 8 pages of cumbersome regulations that will cost jobs and deter entrepreneurship in Missouri. Some of the requirements that are in Prop A, just in the 8 pages of regulations that the voters did not see on the ballot, that really are harmful to businesses include, there's an exemption for businesses that are under $500,000 in sales. Well, that's great, but that number came from decades ago and hasn't been increased for the cost of inflation, so that number would be closer to 9 million if it was indexed. It exempts golf caddies and babysitters. Couldn't even explain why that would happen. It has a complicated payout structure for salaried employees, commissioned employees, tipped wage employees, that is extremely cumbersome for small businesses to manage, especially if they don't have an HR department. We're talking about small businesses. The owner-operator has to handle all the things involved in payroll. It creates differentials for employers with under 14 employees or over 15 employees, but it doesn't define how you calculate your 14 and 15 employees and what is the cutoff for that. So an employer can be stuck, well, I'll get to that in lawsuits. It allows for unlimited carryover of accumulation of hours. There's no set to stop it. Accrued sick pay transfers with the sale of a business. What kind of a purchaser would say, yeah, I want to buy your business and I want to take all this accrued time that you have as well. That would just say, well, I'll just fire all your employees, and then that just loses jobs again and hire new ones. We also have to hold the liability of the sick pay for 9 months after we terminate an employee, whether they quit or we terminate. We have to hold that liability for 9 months. That's a nightmare, especially when you go through tax season or you go through your billing cycle, and now you're carrying that over for, that's in case we hire them back. The reasons that employees can use sick pay, it's far too broad. It goes into extended family members, domestic violence, closure of businesses. I mean, there's just an unlimited amount of reasons that an employee can use sick pay for. There's fines of $500 a day per employee per instance, plus civil and felony convictions if we don't adhere to the regulations. And then finally, from a restaurant standpoint, if sick pay is enacted on May 1st, it'll put restaurants in violation of either federal food code and local health department ordinances due to the fact that Proposition A states we cannot ask the reasons for your absence. Health department guidelines require us to report any communicable illnesses within 24 hours. So this is why we're asking that, well, we asked in the House that an emergency clause be enacted. We have to break one law if this gets enacted. Either we don't comply with the federal food lines or we don't comply with Proposition A. So this puts operators in a very tricky situation, which goes back to the fines and all of those things. So having said all that, that's why fixing Proposition A is not even an option. Fixing the sick pay, it just needs to be eliminated. It's just too erroneous. And I only listed some of the bigger issues. Every line in there is a problem for a small business. So, and with that, I'll take any questions that the committee may have.
Questions for this witness? Proceed.
Thank you, Mr. Chair. So, did I hear you correctly? Is it the position of the Missouri Restaurant Association that you should fire workers so you can get rid of the sick pay they've accumulated? Is that what you said in your testimony?
No, sir, that's not what I said.
What did you say then?
What I said was Proposition A requires that if a business sells, all the accrued liability for sick pay must be inherited by the purchaser of the business.
Right, and after that you said what?
I said if a purchaser of a business, why would they not just fire those employees and not assume that liability?
Okay, so you assume that you're looking at this like we should... The reasonable thing to do is to fire someone so that you don't have to pay the sick time they've earned?
The reasonable thing to do is not have sick pay enacted and create that liability for someone that's trying to create an entrepreneurship business and open a business in Missouri.
But we do have that right now. That was passed. So your position is that you look at a situation where a person has worked and earned sick time, and your head goes to, if I fire that person, I don't have to pay for their sick time?
No, I look at if I'm an outside person coming to do business in Missouri, why would I buy a business in Missouri if I have to pay accrued sick time? I would just do it in Illinois or in Iowa where I don't have these additional liabilities.
That's wild. And you, as a restaurant association, you're comfortable with workers coming in who are sick? That's a thing that...
No, sir. I'm
Okay,
not
so they
comfortable with
just
workers
should-
coming in the sick. I'm comfortable with a worker telling me what kind of illness they have prior to them being absent from work. And
But you-
Proposition A does not allow for that.
You're against sick time. You just said that you were against sick time.
We would much prefer in the restaurant industry that we
Right.
provide health insurance and wellness, and sick pay connotation means call in. We're much more of, we work as a family. We're a business of opportunity. This is how we operate, not,
I think the truest thing you said was that there's no fixes for this, because you
well,
guys
there is a
convinced me
fix, sir. It's to eliminate it.
I don't think there's, that's not happening. I think the only path you have is to maybe make some small changes, and if your testimony is there's no fixes, I'm going to go ahead and agree with you and say we can come to an agreement that there will be no fixes, because you're not trying to fix it, I'm not trying to change it. So I guess the whole issue, we've narrowed it down, Mr. Chairman, on this hearing is, should Prop A exist or not? And I think, I thank you for narrowing the scope of things that we're fighting about or debating. It's clear that the opponents don't want to make any changes. Proponents don't want to make any changes. So I think we can all just agree, no changes, straight up or down. We'll address it that way. I appreciate your testimony. Thank you, Mr. Chairman, for clarifying this.
Further questions for this witness? Yes, Senator, please proceed.
Okay, so when I look at how the worker earns their sick pay.
1 hour for every 30 hours worked?
Right. But this, think about, well, you work in a restaurant, you're the head of the Restaurant Association. Most likely all of us have worked in restaurants at some point. You're earning this as you go. which means you're working hard, you're following the rules, you're showing up for work, you're being friendly, you're being honest,
Yes.
and following all the rules. And so to me, that shows like the teamwork and effort that goes into a restaurant experience. And it could be Taco Bell, which is one of my favorite places to eat, but it also could be Tony's. Anyway, it seems to me like it feels like this kind of big divide between the owners and management and the people that are actually doing the work. These people are working hard, following the rules. They're a part of a team. They're earning things. It's not given to them. They earn it by showing their loyalty and showing up and working. And so to act like that's something that's not proper is very confusing to me. Because one of the reasons we go to restaurants in our neighborhood, like we go to House of India a lot on Del Mar and 170, they have had the same food service team, same waiters, everything for 20 years. And to me, that means they're a good employer.
Absolutely.
And that's what you want. You don't want turnover and constantly having to train people. So it seems to me like you're saying that these people that show their loyalty by working and showing up and earning some paid sick leave, like that they don't deserve it.
No, ma'am. You're going to take away from the other benefits that we provide to our employees. This will take away the bonuses. This will take away the paid health insurance, the things that are really important. When an operator has to take what little profit margin they have and move this into sick pay, it's going to take away all the things that we do in the community. How many things do you think that restaurant does for the community, the local high school, the soccer teams, the baseball teams? Those all go away when this happens. The profit margin in a restaurant is 3 to 4%. That's not enough to support this. Small businesses simply can't afford it.
So in other states where they have earned sick leave, the restaurants no longer...
If you're asking about California, where it costs $580,000 for a one-bedroom apartment, we're not California. We're in the Midwest.
I don't think we can compare Missouri to California.
I don't
quite
either, but that's
honestly.
what this does. This is exactly what this does. It puts us in a league with California. We're the, 39th state or 39th or 46th in cost of living, but this puts us up in the 9th percentile for minimum wage? 18th, sorry, thank you.
It'll be in the top 8 next year.
Well, the other thing that I'm troubled by, and I'm hoping this is not industry-wide, is for a lot of people that work in restaurants, food service at all levels, 1 star to 5 stars, they have to come to work. If they don't come to work right now, they don't get paid. And I think that is a very, very bad for public health, because people now are forced to go to work and when they're sick in order to make money to keep their utilities on and keep their kids fed and that kind of thing. And I am troubled as a consumer, as a customer, that people have to go to work sick. And I think that's really bad for public health. And so I don't see, to me it seems like a win for food service and for restaurants when an employee can use their best judgment and not come to work when they have something that could be contagious.
I can understand. We wouldn't let an employee that was contagious work, so we don't allow sick employees to work. That's
But
part
then
of what the
then
health
you just
department
send
guidelines
you
are.
just send them home and they don't get paid.
But what we do is many of the people that work in the restaurant industry do it for the flexibility that we offer. You can trade shifts, you can have different schedules. We're not a 9 to 5 Monday through Friday banking operation. We in the restaurant industry, we are probably more accommodating to an employee's personal needs and their schedules than any other industry in the state. And that's what we do. We work around your schedule. It's your first day of school for your kids. All right, we'll trade your shift. You can work on Thursday instead of Tuesday.
I think a
happens
lot of my
frequently.
constituents that work in restaurants would love to work in that scenario where the management is that nice to them. Those are not the scenarios I hear, and I am very concerned that people are doing what's best for their family, which is they still are going to work when they're sick and when they have things that are contagious. And I think, some earned sick leave, it's, in my opinion, not enough. When we're talking about hours versus being able to You know,
Well, where would it stop? Will we stop with when you're pregnant, now we have to pay for you to be off to have a baby, or the spouse has to be off to have a baby? I mean, this is like an inroad into,
yeah, that would be great.
well, it would, but then who's going to pay for the business to stay open? I mean,
Well,
the
you
price
just
of a
said, you just said
cheeseburger is
restaurants are
already
providing health
$12.
insurance. You said restaurants are providing health insurance and other
Yes.
benefits, so you would be paying for somebody to be pregnant. But you want them to come to work?
But, no, so you enact this, and then where's the next step? All right, so now we do maternity leave that's paid, and then we do, it's a slippery slope that we're heading down here.
Okay, so you provide health insurance for a woman who's pregnant. So you're paying for her to have a healthy pregnancy, have a delivery, but then she's supposed to come back to work the very next day because she doesn't have any paid sick leave.
No, ma'am, she's covered under, that's covered under FMLA. Small businesses can't afford to pay for everything.
Okay.
They just can't.
All right, very good, thank you.
All right. Any further questions for the witness? Seeing none. Thank you for that testimony. Thank you for being here. Further witnesses to testify in support.
Good morning, Mr. Chair and members of the committee. My name is Kara Korches here today on behalf of the Missouri Chamber of Commerce and Industry in strong support for this. We really believe that this bill is needed to protect jobs in our state and keep our state economically competitive. You have heard me probably time and time again since about 2020 saying that we strongly believe in our system of free enterprise. That's why we always say, let business decide. We don't like mandates on businesses, and I think you've seen that true. Session after session, we have a principle that we strongly believe in. We believe in our system of free enterprise, and we think mandates that apply to business broadly in a one-size-fits-all approach erode that system of free enterprise. I do want to make the one thing really clear. We encourage our members to pay competitive wages and benefits, especially when you think about this tight labor market. You're not going to keep workers if you're not paying competitive wages and benefits. You can see help wanted signs all over when you drive down Main Street. And so we know that, you know, for businesses, if they're not doing this, it's going to be really hard for them to recruit and retain workers. And that's how the market works. The market, determines if they're able to keep employees, and that's why we don't like mandates. We really do believe this proposition, especially related to paid sick leave, is a job killer. I think all of you that know me, I'm not like an exaggerative person. I don't, use hyperbole ever in my testimony. And this is really rooted in data. So we commissioned a survey of businesses across the state in February. This is an actual commissioned pollster, not a survey monkey with leading questions that's sent out just to our members. And we found in this survey that 1/3 of Missouri's employers say that Prop A's implementation is going to cause them to hire fewer employees. That's a big concern in this global competition for jobs. We want to make sure that our economy is growing jobs, not cutting them. I, too, have heard countless stories from members and non-members across the state about how this is going to impact them, whether they have 250 employees to 10 employees. The implementation of this is really unworkable. I know even just anecdotally at the Missouri Chamber, we offer more than what's required in Prop A and paid sick leave to our employees, and we are going to have to completely rework our policy in order to comply. So whether you think about the carryover, sick time, to the record-keeping requirements, to these new lawsuit pathways that could really sue businesses out of existence, we believe that this one-size-fits-all approach to paid sick leave is unworkable, and that's why we are in support of this bill and can take any questions you may have.
Questions for the witness from the committee?
I have a question, Mr. Chairman.
And I will remind everyone that we do have limited time here, and so would appreciate the degree to which we can ask questions of the witness and not debate the witness, but just for the sake of time, because I know we're going to have a lot of debate on this. Proceed.
So I was not going to ask any questions until the last thing you said. In the last sentence I think you said was that you don't want a one-size-fits-all policy on this. Do you know why we have a one-size-fits-all policy on this?
On paid sick leave? Because
Yeah.
of the ballot measure that was
Yeah, but do you know why the ballot measure had to pass?
No, I guess I'm not following.
Because the Chamber of Commerce and a whole bunch of organizations passed a bill and overrode a Democratic veto that allowed for municipalities and counties on a local basis to set minimum wages and things like sick time. And when that was removed, because this was a local issue, cities and counties were doing that. St. Louis City was passing its own policies that only affected St. Louis City. Kansas City was passing policies that only affected Kansas City. There was not a one-size-fits-all policy. And there was a Republican bill, which a Democratic governor vetoed and was overruled by a Republican legislature with the strong support from the Chamber of Commerce that banned that. And so the reason we have a one-size-fits-all policy is because of the actions of this legislature and because other avenues have been shut off historically. And that's an important context for this bill, why we're talking today, and for anybody out there who wants to say we don't need a one-size-fits-all policy. There is a very specific reason that we have to go down that path, and it's because you vehemently opposed any other path, and you as organizations, not you personally, but you as organizations prohibited any other path, so this was the only path to take. So for anybody out there who wants to say that in any testimony, just know that will be the response. That is the reason that we are here. Thank you, Mr. Chairman.
Further questions from the committee? Seeing none, thank you for being here. Further witnesses testify in support. Please proceed when ready.
Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries in Missouri, also want to go on record in support of this bill. The ballot question that was presented to voters contained more than one subject, which is in violation of the Article 3, Section 50, I believe, of the Missouri Constitution. There is a lawsuit pending right now at the Missouri Supreme Court on that matter, and we hope to have a decision soon. But in the meantime, we're hopeful that some legislation will pass that will bring some reasonable resolution to this. There were a lot of details that weren't contained that voters never saw, and those are really the things that give us the most trouble. The fact that you can't ask an employee why they're calling in sick. The fact that you can't require a doctor's excuse unless someone calls in for 3 consecutive days. So they can call in for 2 days, they can come in for an hour, and then take off again, and you can't ask them for a doctor's excuse. Many of the details, including allowing lawsuits against employers with a special section that's dealing just with lawsuits against employers, are very problematic. And for that reason, we're very supportive of the current bill and happy to answer any questions.
Questions for this witness? Seeing none. Thank you for being here. Further witnesses in support? Please proceed when ready.
Thank you, Mr. Chairman, members of the committee. My name is Dan Shaw. I'm Executive State Director for Missouri Grocers Association. We are here in support of this bill. As we've testified before, our main concern is food safety, where as the restaurants talked about not being able to inquire about what illness they have to figure out if they're fit for work. Our main goal is to provide a good quality, safe product at a reasonable cost to the consumer regardless of geography, regardless of the zip code. We don't want to have food deserts. We just testified Monday evening in Springfield in support of helping them with food deserts. I'm afraid if this bill goes, or the proposition that stands and this bill fails, that we'll have not only food deserts throughout the state, but also retail deserts as well. The representative in her opening statement mentioned the 21% pay increase on just the minimum wage. The grocery industry is a 1% to 2% margin at the end of the day. 21% doesn't go into 1% to 2%. I don't know how that works. Senator, you spoke of the reason we have a one state minimum wage. I believe I know the intention of the General Assembly at that time was to get the government out of the business of setting minimum wage and letting the economy set it and let the marketplace. And we still believe that today. With that, I'll take any questions.
Questions for this witness from the committee? Oh, surely. There's some questions. I was trying hard.
Bring it on.
Thank you for being here. Thank you for that testimony. It's good to see you again. Further witnesses in support?
Mr. Chairman, Brad Jones with the NFIB. We do support this bill. I was thinking about going into some economics, and I decided not to. So I had Walter Johnson at MU, by the way, so don't mess, yeah, he was great. Walter Johnson was one of the greatest economists. The only thing is, his lectures were the best you have ever heard in your life. They just didn't seem to have anything to do with the test. So, anyway, we do support the bill very much. Thank you.
Thank you. Questions for this witness? Seeing none. Further witnesses in support? Please proceed.
No, my economic professor is from New Zealand, and I couldn't understand a word he said. I did better with my German professors in engineering. But beside the point, good afternoon, Mr. Chairman. David Overfelt, President of the Missouri Retailers Association, and of course, we are in favor of House Bill 567.
Questions for this witness? Seeing none. Thank you again for being here. Further witnesses in support?
Mr. Chair, members of the committee, Nikki Strong here on behalf of Marquette Transportation Company. We are a barge company that operates up and down the Mississippi River and sometimes on the Missouri River. We think that the barges and towboats along the rivers have a unique take on this. We transport products such as our ag products, beans, corn, fertilizer, et cetera, billions and billions of dollars from the Gulf all the way up to the border. Missouri is home to over 8,700 maritime jobs, generates $503 million in labor income. The barge industry is unique in the way that they operate. They have flexible hitch work schedules where a lot of times you're on 28 days, off 28 days. So it's important that those barge operators are there. Our employers receive generous pay. Their benefits, while they're on the barge, they're provided telehealth services, mental health services, even have access to necessary medications. They also comply with the federal Fair Labor Standards Act. They can work with shoreside staff if necessary, if they need to leave the boat, but it's important that they're on the boat because if they're not on the boat at any given time, that boat stops. And if that boat stops, that product stops, and that product cannot make it to wherever it's supposed to go. So due to the unique operations of the maritime industry, we require the laws or regulations that we have to abide by at any given time to accurately reflect the movement and supply movement and schedules and activities that a barge provides. We're very similar to the railroads, and railroads were exempted from this. So for that reason, we're in support of the paid sick leave portion of this bill. Be happy to take any questions.
Questions for this witness from the committee? Yeah, proceed, Senator.
So my understanding of how these shifts work is, you know, you're on day 4 of a 28-day operation, and if you get sick, you just go back to your cabin. Like you have your room is right there. So I don't see how that's a problem for a barge operator. That if the person's sick, they're sick, and they go to their room.
So when our legal counsel has looked at, and I think to the point that people have said before, the complexity of the paid sick leave that is in our law now, they believe that they have to comply. And if that worker says, I need off now, I need off the boat. To your point, yes, they can. We do provide the rooms. You know, we provide I don't want to call it an infirmary, but we can serve.
And
right.
But there's a kitchen and everything.
Right.
I mean, they basically are living there for 28 days.
Correct.
I just don't see, I don't see any scenario where a worker is going to be in the middle of a 28-day commitment and they're going to want to have like, paid sick leave off the boat, off the barge. I just don't, I don't see that scenario.
I believe
quite
our
honestly.
interpretation, our legal counsel doesn't interpret it that way. So that there would be a scenario where an employee could say, under this law, that would conflict with what they have in place now.
Okay.
Further questions? Seeing none. Thank you again for being here. Further witnesses in support? Seeing none. Any witnesses here in opposition? Please come forward, make sure you fill out a witness card, and proceed when ready.
I wrote good morning, but probably it's good afternoon, Mr. Chairman and members of the committee. My name is Richard Von Glahn. I'm the Policy Director for Missouri Jobs with Justice, on whose behalf I am speaking today. I've worked on the issue of minimum wage in Missouri for over 20 years, including the 2006 2018 and most recent ballot campaign, as well as the municipal campaigns in St. Louis and Kansas City and the legislature repeal of those ordinances. In all those campaigns, we were told to be terrified of the consequences, the consequences about putting some common sense guardrails up around our economy and how we as workers should expect to be treated. I've seen that those predictions don't pan out. I'm here today because I've listened to proponents of House Bill 567 misrepresent the intentions and likely impact of Proposition A. And I want you all to be equipped with the understanding of how it works and why it is important. Proposition A was modeled on paid sick leave policies that 18 other states and dozens of municipalities have passed. It was designed to allow workers to gradually earn sick time on an accrual basis. 1 hour of paid sick leave for every 30 hours worked, just like 15 other states do, and how I often hear from this chamber that we need to incentivize work and encourage workers. If employers do not wish to track the accrual process, they have the option to front load the time if that is what works better for them. Employers can limit how many hours a worker can use. If they are a seasonal employee, they can require the worker to first earn time before they use it. If they're under 15 employees, they can limit total usage to 40 hours a year. Larger employers can cap it at 56 hours per year. It doesn't matter how much time an employee earns, employers can always limit usage. The law does not pay out unused sick time when an employee separates or at the end of the year. The employer can do that if they wish, but it is again the employer's discretion. Sick leave caps out at 80 hours to carry over a year, but it does not arbitrarily expire. This is the same as all other 18 states, because what we don't want is workers lose all of the time that they've earned on December 31st, and come January 8th, they're sick, and they don't have time that they can use. Arbitrary expirations just don't make sense, and it's why we don't see any other state have that policy. The law allows employers to ask for a doctor's note after 3 days, but not one. The Kaiser Family Foundation reports that the average copay is $26. And most workers, and frankly most doctors, don't want us clogging up their waiting rooms for routine illnesses. The law specifies that this does not apply if it is in conflict with another law. So speaking to some of the previous testimony that we heard, if there is a legal requirement for workers to communicate about their illness, that is allowed under Proposition A. Finally, the law protects employers who are trying to do the right thing. It does provide for a private right of action, as employees must have some way to hold negligent employers accountable, but only for willful violations. Willful is defined in the Oxford Dictionary as having or showing a stubborn and determined intention to do as one wants, regardless of the consequences or effects. I'll be happy to answer other questions about how the law works if you have them, but I also want to talk about why the law is important. We should start that by acknowledging that businesses do know how to provide paid sick time. The Bureau of Labor Statistics estimates that 79% of private sector workers have access to paid sick time. So this isn't really a question of if we can do it. The question is if we want to and if we think all workers are deserving of this benefit. This gets to the crux of the debate for me. While over 90% of the highest wage earners have access to paid sick time, less than 40% of the lowest wage earners do. Do we think lower paid workers are less likely to get sick? Of course not. In fact, lower wage workers who often work in public-facing jobs like childcare, nursing care, retail, and food service are the most likely to get sick because of how much they interact with the public and other humans. This leaves me with only one other conclusion about this bill. Proponents simply do not think that lower wage workers deserve the opportunity to earn the same benefits that their bosses get. Proposition A was passed with over 57% of the vote, winning 10 Senate seats held by Democrats as well as 10 Senate seats held by Republicans. It won in rural counties, suburban counties, and urban counties. It got more votes than U.S. Senator Josh Hawley. Proposition A was put on the ballot thanks to the efforts of over 900 Missourians who gathered signatures in every single Missouri county. They gathered over 210,000 in total. It was publicly endorsed by over 500 businesses, small Missouri businesses, and over 135 community organizations representing every single corner of this state. There was an opportunity for a debate around the merits of Proposition A. Opponents made their argument, we made our argument, and voters spoke. House Bill 567 is a refutation of the public will. It will make Missouri workers more likely to have to go to work while sick, jeopardizing their own health, the health of their coworkers, and of Missouri workplaces. I believe Missouri is capable of the same just laws that 18 other states have managed to pass and implement. House Bill 567 is simply a solution in search of a problem. Thank you. I'm open for any questions.
Questions for this witness from the committee? Proceed.
Thank you, Mr. When you were campaigning, there was two things really, and there's the minimum wage increase and the sick time thing. They were in the same chapter, and I know there's some testimony that's multiple subjects. If that was the case, a lawsuit would have knocked it out. We wouldn't even be here today. But my question is, when you were campaigning, did you hear more from folks about the minimum wage increase or about their earned sick time, or was it a combination of both, or what was one pulling the other? What did you kind of see?
Yeah, I mean, I will say in the signature gathering phase, actually many people were surprised that the minimum wage wasn't already $15. People look around at the marketplace, they consider what it is, what it would take to live in Missouri counties, with rent going up and different things going up. And so they sort of already assumed that $15 is already there. So often when we talked about that, people will kind of shrug their shoulders and say, oh yeah, okay, that seems fairly obvious. Sick days was the thing that we got more interaction from people on, and people really thinking about it. Certainly in building the coalition, both on the business and the community organization side, a lot of people, thought about sick days, the importance of for instance, being able to take sick leave to care for a child, the importance of that child's well-being, and having a stable home that they can be able to grow up in and do that. A lot of the public health considerations. Sick leave was probably the thing that animated more of the support on the initiative.
Further questions? Seeing none. Thank you for being here and for that testimony. Additional witnesses testify in opposition. Please proceed when ready.
Thank you, Mr. Chair, members of the committee. Mandy Hagseth, Director of Policy with Missouri Family Health Council. We were an agency among the 600 businesses and organizations endorsing Proposition A, and as such, especially because of the earned sick time provision and public health considerations, we hope that you will reconsider moving this proposal forward. Thank you so much for your time today.
Who did you say you were with? I'm sorry, I missed it.
Missouri Family Health Council.
Okay, thank you. Questions for this witness from the committee? Seeing none. Thank you again for being here. Further witnesses in opposition? Seeing none. Maybe one? No. Any? Are you here to testify? Okay. Please come forward and proceed. I thought you were leaving, not testifying.
Sorry. Good afternoon. My name is Maggie Olivia. I'm here on behalf of Abortion Action Missouri in opposition to this bill. Abortion Action Missouri cares about pregnant people and families and keeping families together, and that's why we were really proud to be a part of this coalition to pass Proposition A. Our volunteers collected more than 20,000 signatures across the state. And we know that because women dominate low-wage industries, they often must jeopardize their wages and, frankly, sometimes even their entire jobs when they have to take time off to care for themselves, a sick child, or other loved ones. Subsequently, they are jeopardizing their wages, their families' livelihoods, and access to critical medical care. pregnancy and the postpartum period are major medical events, and people who do decide to build and raise families in our state face some of the highest rates of maternal and infant mortality. Black women in particular face the most risk in birthing and postpartum care management, and, face the most risk. And all people who are pregnant or in the postpartum period deserve paid sick time to adequately care for themselves and their families. The National Partnership for Women and Families estimates that for the typical working family, that 3.5 sick days without pay is equivalent to losing an entire month of groceries. Lack of access to earned sick leave contributes to Missouri's gender wage gap, and research demonstrates that workers who do have access to paid sick leave experience better economic and health outcomes, and that is the same for their children and families. So for that reason, we oppose this bill. Thank you.
Thank you. Questions for this witness from the committee? Seeing none. Thank you again for being here. Further witnesses in opposition? Please proceed.
Good afternoon, committee members. My name is Sage Coram on behalf of the American Civil Liberties Union of Missouri. We're here to go on record in opposition to this bill and any attempted rollback of the voter-approved measure of Proposition A as an issue of economic justice. I ask you today to respect the will of the people and the dignity of all workers in Missouri by opposing this measure.
Mr. Chairman.
Yes, proceed.
I'm sorry, I just didn't hear who you are, who you represent.
Oh yeah, Sage Coram, American Civil Liberties Union of Missouri.
Thanks so much.
Questions for this witness from the committee? Seeing none. Thank you again. Further witnesses in opposition? Please proceed.
To Chair Trent and the rest of the General Laws Committee, my name is Marcel Hagans. I am the Action St. Louis Power Projects Policy Coordinator. I am here to oppose House Bill 567 and to speak out against the state's attempt to undermine participatory democracy and weaponize its power to silence the voices of Missourians statewide. Excuse me. When Missourians went to the ballot to cast their vote on November 5th, 2024, many were living in a reality that saw many of them rent-burdened, underpaid, and unsupported. The housing market saw historic rate increases while wages remained stagnant, a post-epidemic job market that hasn't fully recovered, and employers removing worker protections in the name of cost-saving measures. The results of those votes cast saw Proposition A, an initiative spearheaded by organizations like Missouri Jobs with Justice and Missouri Workers Center to increase minimum wage and offer paid sick time for employees, passed with 57% of the votes cast. Missouri voters made their voices abundantly clear. A living wage and the ability to manage personal affairs like health care and child support without the fear of losing a day wage or their jobs entirely should be something that all Missourians deserve. The introduction of this bill in the following session, a mere months after the passage of Prop A, stripping mandates that Missourians made clear should be in place, made it clear that the government is not in support of the Missouri worker and will undermine participatory democracy to prove as much. For this and the clear implications that repealing this language has on the backbone of this state, the Missouri worker, we vehemently oppose House Bill 567 in any language that would silence direct democracy and expose the most vulnerable of us to more harm. Thank you.
Thank you for being here and for that testimony. Any questions for this witness? Seeing none, thank you again. Further witnesses in opposition? Seeing none. Any witnesses here testify for informational purposes only? Seeing none, that will conclude the public hearing on House Bill number 567, 546, 758, and 958. I know we have one more bill that we want to hear, but I appreciate having the full committee here right now, and I know that folks have other places to be, so we're going to quickly, hopefully quickly, do executive session. So I move that the committee go into executive session. It's been seconded. All those in favor, please signify by saying aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. The committee is now in executive session. I first move that Senate Bill number 247 be brought before the committee. It's been seconded. All those in favor, please signify by saying aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. The bill is before the committee. Senate Bill number 247 is the bill brought forward by Senator Serpoy. This is the land conveyance bill for Lee Summit, Jackson County. And I move that the committee vote do pass Senate Bill number 247. Any discussion? Seeing no discussion, I renew my motion. Madam Secretary, please call the roll.
Senators Trent. Aye. Gregory. Aye. Bernsketter. Aye. Carter. Aye. Coleman. Aye. McCreary. Aye. Weber.
By your vote of 7 aye and 0 no, you have voted to pass Senate Bill number 247. I now move that we bring Senate Bill number 289 before the committee. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. The bill is before the committee. Senate Bill number 289 is the Trust and Estate Electronic Wills bill from Senator Berger that we heard several weeks ago now. The Missouri Electronic Wills and Electronic Estate Planning Documents Act. And I move that committee vote do pass Senate Bill number 289. Is there any discussion? Seeing no discussion, Madam Secretary, please call the roll.
Senators Trent. Aye. Gregory. Aye. Bernsketter. Aye. Carter. Coleman. Aye. McCreary. Aye. Weber.
By your vote of 7 ayes and 0 noes, you have voted to pass Senate Bill number 289. I now move that the committee, or that we bring before the committee House Bills number 567, 546, 758, and 958. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. The bill is before the committee. So this is the bill that we just heard in committee on Proposition A and the minimum wage paid sick leave. Normally, we usually have a week that transpires between bills. However, I think it's extremely clear, especially after the hearing, that there is, this is a debate that ultimately has to be held on the floor. That there is not really an opportunity for further deliberation by the committee because whatever happens here is ultimately the floor is where that debate is going to have to play out. And so I believe it's appropriate to move this forward immediately so that we can have that robust debate and consideration on the floor and have plenty of time in which to do it. So I make a motion that the committee vote do pass House Bills number 567, 546, 758, and 958. Do I have a second? It's been seconded. Any discussion? Yes, Senator, please proceed.
I'm concerned about there's been only one other time so far in the Senate where I've been here that we voted on a bill the same day, and I think there was a specific reason for that. So I'm not sure the justification seems to be a general one that would apply to pretty much any bill. So I'm a little concerned about that. I will say, not that there's a lot of hope for it, but I think moving the bill, if that's the approach, I think any idea of negotiating anything on this bill is probably dead. So if that's, after the testimony we heard, it's probably on life support anyway. But just want to be clear that if anybody's thinking that maybe you can get a fix or jot it, if we go ahead and move it this quickly, I think that's probably done. So just want to be clear about that.
Oh, I certainly appreciate those comments, Senator. Yes, Senator, please proceed.
So we're noticed up for tomorrow. Why wouldn't we just have a vote tomorrow? There are people on my calendar this afternoon that want to talk to me about this bill this afternoon. So it seems like you had a plan to at least give us a chance to finish our meetings today with people that have come in from out of town to testify for or against this bill.
The purpose of having a hearing tomorrow is that it can sometimes be difficult just because of the tempo of the pace that we have at this juncture in session. It's difficult to get everyone in the same room, but we have the benefit of having the full committee here today to consider this. Further discussion? Seeing none, I renew my motion. Madam Secretary, please call the roll.
Senators Trent. Gregory. Bernsketter. Carter. Coleman. McCreary. Weber.
By your vote of 5 ayes and 2 noes, you have voted to pass House Bills number 567, 546, 758, and 958. I next move that we leave executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. We have exited executive session. We will now hear our final bill, Senate Bill number 320 by Senator Schroer. Please proceed.
Thank you, Mr. Chair, members of the committee. I'm going to be fairly quick on this one, as this bill has been around for many years, since at least 2017. For the record, State Senator Nick Schroer from Senate District 2 on Senate Bill 320. This is the joint employers bill that I've carried since I was in the House. Former Senator Onder had it in my time when I was in the House, and now I'm carrying that, which basically is several decades of federal precedent that we're going to enact in state law that holds that neither the franchisee or their employees shall be considered actual employees of the franchisor unless they exercise direct and immediate control over several things: the hiring, the terminations, discipline, and the direction of the employee. So nearly half the states have passed this, and we've gotten it out of the Senate many times. We've gotten it out of the House many times. Just trying to get both chambers in a direction to where we can do it this year together. So with that, I'll open it up to any questions.
Questions from the committee? Seeing one. Yes, Senator, please proceed.
Good afternoon.
Good afternoon.
So I'm trying to understand this a little bit. And, you know, sometimes you, like in the neighborhood, you see all these different delivery drivers coming around, for example. So if somebody works for, if somebody's like I don't know how to say this, like they have they're an
like an independent contractor.
An independent contractor, but they work for, say, they're doing deliveries for FedEx, for example. Are those people that are driving around my neighborhood with like a FedEx shirt on that are that are being considered contractors, are they also allowed to do deliveries for other companies? Because if they're independent contractors, they should be able to deliver for multiple.
Well, it really depends whether, you know, independent contractors in that realm or even Uber, Lyft. You see, you know, people driving around and all of a sudden the Uber light will light up or the Lyft light. So they're representative of that company in particular, but holding the franchisor. So let's just take Chick-fil-A, because that's a big one right now that's popping up everywhere. If you want to be a Chick-fil-A franchisee, I forget how much it is, and someone will correct me in the background, but if Chick-fil-A as a national headquarters exercises, and this is what the federal precedent has been up until recently, where it started going back and forth between Bush and then Obama and then Trump and then Biden, now back again to Trump, and that's where a lot of the states are acting. But if they don't exercise the four prongs, oversight on hiring practices, termination practices, discipline practices, and direction of employees, then they would not necessarily be connected to that national headquarters. If you're just buying a Chick-fil-A and you're going to do it on your own, and you've got your own HR practices, hiring and discipline practices, then typically you are going to be separate and aside from the franchisor.
So if the person's a contractor, then they should be able to just say for no reason that they're just not going to work, and they, you know, because like it's field day at school, and I want to go with my daughter to field day. So if they're contractors, then they should be allowed to do that, because they set their own schedules and that kind of thing?
Yeah, so that would be dependent upon their contract and how they're held in that company. If they've been held to a contract that, hey, Monday through Friday, you will be here pursuant to the contract, or if it's, you know, somebody who, like an Uber or a Lyft, I'm going to clock on and whatever comes my way. And I don't know how, I've talked to a lot of different Uber and Lyft drivers with all of the different traveling that we do for this job. And I kind of get a grasp on, they can clock in, they can clock out if they want to.
Yeah, I think I'm thinking more of like the people that are wearing, they have the truck, they're wearing the logoed shirt, the company's telling them the route, they're giving them the packages to deliver. if they're truly just contractors, then they should just say, oh, I'm not doing that today.
Yeah, so typically, I don't think, in most circumstances, they're not going to fall under this. But if, let's say one of those independent contractors runs somebody over, and they're working for FedEx or UPS or Amazon, whoever it may be, I think through the discovery process, you're going to be able to find out, can we hold the national FedEx, the national USPS or UPS accountable for this? Because I know a lot of UPS or USPS has been contracted by Amazon for some weekend
especially
deliveries.
On the weekends too.
Right, so there's got to be some sort of memorandum of understanding when it comes to liability. But ultimately, we're just trying to get uniform and stop this madness of going back and forth with the NLRB. And this has been decades of precedent that we're just trying to solidify that in order to get to that franchise, or here's the framework that you will have to establish within that legal process.
Okay, yeah, and I hear what you're saying. There's part of me that is a bit suspicious that some franchisees are trying to get around, like, following all of the rules by saying that the people are contractors. But if you wear the logo, you've got the van, they tell you the route, it's like, to me, it's sort of a gray area where it's maybe just somebody trying to get around, how the workers should be classified. So
and I'd be more than happy, as you know,
Okay.
to work with you
Yeah.
on trying to fix whatever issues
very good.
we
Thank
may
you.
have. Yeah.
Appreciate your patience. Thanks.
Further questions for the bill sponsor? Seeing none. Witnesses here testify in support.
Mr. Chair, members of the committee, Michael Henderson on behalf of the U.S. Chamber of Commerce and the American Hotel and Lodging Association support this legislation to provide clarity and certainty to our businesses here in Missouri. As the bill sponsor stated, this is just codifying current federal law for substantial direct and immediate control. A number of other states have already passed it. We're in favor. Thank you.
Questions for this witness? Yes, proceed.
Thanks for being here. Could you give me a few examples of, like, positions or kinds of workers that would be, because you said hotels?
Yes, correct.
Okay.
And so I think a good example here, Senator, would be if you have the local franchisee or the business that actually hires, fires, employs housekeepers, bellmen, front door persons. They may be.
So a hotel, so you've got the physical structure.
Correct.
And you've got the owner, but they're not the ones staffing the place.
Well, no, and
No?
and so that would be the franchisee. They may be licensed under a large chain, so they're flying the flag of a large hotel nationwide, right? That would be the franchisor. For this purpose, really, that name of the hotel, whether it's a Marriott or a Courtyard or a Drury Inn, is simply licensing its name and its branding to this business here in Missouri, the franchisee. And what this bill would say, essentially, just by virtue of licensing out your name as the big corporate chain, you are not considered to be the employer of those individual employees if you have no involvement in their hiring, their firing, directing their employment, those sorts of things.
Okay, so it's a little bit like a step removed. So you've got Marriott, and where their headquarters is, and then there's a local franchise that owns the hotel here.
Correct.
Those are the people that are setting the work rules and that kind of thing.
Correct.
Okay, very good. Thank you.
Yes.
Further questions for this witness? Seeing none.
Thank you.
Further witnesses in support?
Mr. Chairman, members of the committee, Organ Schlemmer on behalf of the Missouri Hotel Lodging Association. So, Senator, I think to answer your question maybe is, the one that we always hear about the most is Best Western and Super 8. I think the example of a contractor helping out on the weekends or whatever the case may be, they're not a franchisee. They're actually a contractor. But FedEx isn't saying, here you go, you're a franchisee, you have to go open a store. In order to fly our flag, you have to be open at this time, and you have to use our computer systems, you have to do all these different things, right? They're not actually running a store. They're actually working for an entity directly as a contractor to go deliver their packages for that day. This is a franchisee Best Western, Ritz-Carlton's another one. Wouldn't Be Drury, I think, is all wholly owned by their own corporation, but Super 8s, and they say, hey, we want to be a Ritz-Carlton. Okay, well, in order, you got to have this kind of a quality restaurant. You got to do this, this, and this before you can put our name on your building. And they get that permission. They stick the name on their building, but that owner of that building and that franchise, that location of Ritz-Carlton, is making their own hiring and firing and discipline and all the different arrangements. The entity that they're having to pay to go fly the Ritz-Carlton flag doesn't control any of those items, and therefore I think this is what the senator's bill is trying to do, is say, hey, you are making sure you told these folks before you can fly the flag you have to do all these different things, but if somebody slips and falls or whatever the case may be, that's not this person. This is this person who owns this business. They've just paid for a Chick-fil-A or Super 8 or whatever the case may be. So, yeah.
Further questions for this witness? Seeing none. Further witnesses in support?
Good afternoon, Chair Trent, members of the committee. My name is Luke Reed. I'm with the Missouri Chamber of Commerce and Industry, here to voice our support for Senate Bill 320. It clarifies the employment relationship between franchisor and franchisee and basically takes a snapshot of the current federal precedent. And as the sponsor has mentioned, it's flipped back and forth based on the administration. So we want to take a snapshot of this current one for these disputes. Yes, because like the parent company, the Best Western, or I don't want to use a current business, but a Circuit City. That's a Circuit City on the outside of it, but the Circuit City corporate is not hiring and firing the workers. That is the owner of the Circuit City branch in Jefferson City. So that's the clarification this is.
Questions for this witness? Seeing none. Further witnesses in support? Seeing none. Any witnesses here in opposition? Seeing none. Any witnesses here for informational purposes only? Seeing none. That will conclude the hearing on Senate Bill number 320. With no further business coming before the committee, I move that the committee stand adjourned. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. Committee is adjourned.